Hi, Jim Selbach here. We're going to take a couple of minutes to talk about an issue that comes up a lot in stay violation motions, and that is before a motion for a willful violation of the automatic stay can be filed, is there any requirement that you do something first? Do you have to reach out to the creditor? Do you have to warn the creditor? Do you have to send them a letter or make a phone call? Many practitioners think that there is such a requirement. The law does not impose any such a requirement on debtors. Unfortunately, some judges even think there's such a requirement, but you'll see today the law does not require that. Now, the first thing to point out is that our firm, the system that we developed, which is very effective, by the way, takes the approach that you find in the statute. And that is, when your client comes in with a bill or a letter or something happened, they got a phone call, there is no requirement and there is no need and there is no purpose in reaching out to the creditor or warning the creditor who already has notice of the bankruptcy case. So we take the approach that the motion should be filed immediately. The traditional approach is kind of, try to reach out, try to make a phone call. You'll see that's unproductive, it's not the law, and it makes no sense. So the first question is it legally required? So if you just look at the statute, the answer is clearly no. If Congress wanted to require a notice as a precondition to filing a willful violation, it knows how to do that. In fact, it has done that in other federal consumer-based statutes, and there's, of course, lots of them. So let's take a look at one, and that is the Fair Credit Reporting Act. Now, the Fair Credit Reporting Act makes it illegal not to have a false statement in a credit report. It makes it illegal to keep a false statement in a credit report. And here's what it says, that if a consumer disputes the accuracy of an item in a credit report, the credit reporting agency must conduct a reasonable investigation and delete the item within 30 days if it is, in fact, incorrect. Now, the statute also says that if the Bureau fails to do this, the consumer can then bring an action in district court. So in that statute, what Congress said is before you can bring an action for violation of the Fair Credit Reporting Act, you have to give the credit reporting agency a chance to fix it first. You have to file a dispute. The consumer has to file a dispute. And then if they don't fix it, then you can bring an action. But there is no such provision like that in the bankruptcy code anywhere. It doesn't say that. It just says if there's a violation, you bring a motion. So what about the courts? Well, some courts say yes, some courts say no. Let's take a look at some of the local decisions, at least one from former Chief Bankruptcy Judge Stephen D. Gerling. It was in a case that we had, and the creditor took the position is we had to fire a warning shot over the bow of the creditor first. We had to warn the creditor. And here's what Judge Gerling said. Such a requirement would place an unreasonable burden on the debtor to forewarn the offending creditor to cease and desist before debtor's counsel could reasonably file a Code 362H motion. So what Judge Gerling did, just looking at the statute, said there is no requirement for that, and why would you impose that burden on the debtor? The violation has already occurred. The creditor already had notice. So the court rejected that argument. Here's a quote from a court in the Southern District of Ohio, where the facts indicate a willful violation of the automatic stay. It is improper to impose a blanket rule on all debtors, require them to notify creditors to try to resolve the violation prior to filing a contempt motion. A pre-filing notification would serve as a last-minute attempt to prevent needless litigation. In most cases, however, such a requirement would thwart the policy of Section 362 by unfairly shifting to the debtor the burden to alert the creditor to stop acting in a fashion which the creditor already knows or should know is improper. Since the creditors have notice, they have the burden to act accordingly. And I might point out, and as practitioners we know this, most of the time when you reach out, you're wasting your time. They don't stop. They continue to send bills. It's a waste of your staff's time to try to get some of these things stopped by, quote, reaching out or sending a warning shot. It's not the debtor's burden. It's not required in the statute. And by the way, it's a waste of time. So there is no legal duty. And the other point is that it's counterproductive. The traditional approach, you're wasting your staff's time. The violation is not getting taken care of. Your client is getting upset because nothing's happening. You're not being compensated for the waste of your staff's time. And there's a much better way, and that is to file the motion. Now, what about emergency situations? What about your client comes in and they've got an income execution and they want that off their wages? It's been a month, it's been 2 months, and they're still garnishing their wages. Some practitioners think, well, it's quicker and easier if I just try to reach out and get it stopped. In actuality, in our practice, it's quicker if we file a motion. And here's what we do. This is a good example of the effectiveness of the stay violation motion. We have, of course, many of these in the pipeline, but when one comes in where there's an income execution, we put that to the front of the line. We immediately file the motion. We get a PDF file of the filed motion and we email it to the attorney. And I can tell you from practice that day, sometimes within an hour, I get a phone call. Oh, I'm sorry, we didn't, there's always some excuse. We've already pulled the income execution. What do you want? And of course, when we handle it by way of motion, the income execution is stopped immediately. The client gets money, which they weren't anticipating. Your office gets money. We get paid. The stay is enforced, not only for this debtor, but for every debtor. So when you have these emergency situations like income executions, maybe there's a bank restraint, maybe they're taking money out of the client's bank account, we can get that stopped probably much faster than you can, and we can save your office the time of fooling around with something that we can handle much quicker. Now let me give you a recent example of a case that we had. The debtor walks into the 341 meeting with a summons and complaint, okay? The credit card company had sued the debtor, gives the summons and complaint to the bankruptcy attorney. The bankruptcy attorney gives the summons and complaint to a staff member with instructions to contact the debt or the creditor's attorney and get this stopped, which the staff person did dutifully, called them, got through to them, told them, look, this person's filed bankruptcy, you can't be suing them. What happened? Nothing. They did nothing. So this went on. Finally, it came to my office. When my office got it, the next day, we had settled that case for a specific amount of money. We had a stipulation of discontinuance, stopping the lawsuit. The client got, I think it was $1,400. We called the client, the lawsuit's been stopped, you're getting $1,400, everything's taken care of. The client was obviously happy that we stopped the lawsuit, which is all they really wanted to do in the first place, and was ecstatic that they were getting $1,400. And this call could have been done. That staff person didn't have to make any phone calls. All she had to do was simply refer the matter to us. So our system works better. It immediately stops the violation. It recovers money if money needs to be recovered. It eliminates work for the debtor's attorney staff. The debtor gets money. The debtor's attorney gets money. It works It's a win-win for everyone. So to sum up, there is no requirement to do a reach out before filing a motion. Every violation, whether it's one bill, one letter, one phone call, according to the statute, requires the filing of a motion. And that's what we do. Thank you and have a good day.